today.
Thank you. Thanks, Senator Hill. We got a series of questions from Senator Brass. If we can be as quick as possible so we get some testimony.
Chairman, I'll be as brief as I can. Senator, when we're drawing, or when the maps are drawn and we're looking at districts, would you agree that only numerical factors that we're able to look at are population and political data currently?
No, I don't think that's true. You can consider other characteristics, but there's, of course, huge bodies of case law about how that will be done.
Right, and that case law says that you're only allowed to look at population and political data.
No, because the Voting Rights Act wouldn't have it quite that way.
Well, are you familiar with the Shaw line of
Sure.
cases?
Yes, and so what you're getting at is so in the Shaw case, if you cannot draw a district solely on the basis of race. However, which is basically what Shaw's holding was. However, if you don't take into race in account at all, so that there's no opportunity for racial minorities, say, to have any opportunity to have to select a member, a representative of their preferred representative, then that also would be violative. So basically you can, under all those cases, you can violate it on either side.
Okay, well, basically what Shaw says, and the way I've interpreted it, is that you cannot use racial data as the primary metric, which we
Primary,
agree.
I agree, that's right, yes.
But you can use political data.
That's right, and so what you're getting at is sort of a line of cases that would have suggested over time that a racial gerrymander is impermissible, but a partisan gerrymander is permissible. And that's what's being heavily tested in the courts as we speak. So just yesterday, Wisconsin appealed their ruling to the Supreme Court, and their ruling was, no, it is unconstitutional to gerrymander or draw unfair districts for partisan advantage. And so these are the new line of cases, and they're coming up in Maryland and North Carolina as well. And what's interesting is that, like, a while ago, at least 10 years ago, and I've got a voting rights litigation expert who's going to testify next who can really drill down into this, but however many years ago, the Supreme Court, especially Justice Kennedy, said, look, partisan gerrymandering is clearly unconstitutional. It's violative of the Equal Protection Clause of the 14th Amendment. The question is, how can we devise a test that will be able to be applied across a variety of cases? Because if we can't devise a test that's going to work and that legislators could use or independent commissions could use when they're forming maps, how can we then throw it out later? You know, we need some continual applicability. So that's what they tried to generate in Wisconsin, and it's basically an analysis of wasted votes or an efficiency gap between the districts, between the parties. So that's on appeal right now. But I mean, this is totally my own opinion. My opinion is that the courts have seen how, as Chairman Hill mentioned, polarized and dysfunctional Congress has gotten, and they are saying, for the good of America and democracy, we are going to have to intervene on these wildly anti-democratic maps that are stanching compromise and even voter turnout.
Right. Look, I appreciate what you're trying to do. My concerns are on how we're trying to do it. If this commission isn't going to look at political data, it's not allowed by law to look at racial data, then how are we going to draw the majority-minority districts according to the Voting Rights Act?
No, you would be able to. You just cannot, race cannot be the sole determinative factor. But you would, of course, have to look at racial data. And you would sort of know how, and there's nothing that you can't look at political data. You just can't draw it to favor or disfavor a certain political party or incumbent. That doesn't mean you don't have the data. Would you be in concurrence?
I mean, do you think the Voting Rights Act is causing some of these issues?
You know, I think that you can say that. No, I mean, what I believe a fair answer to be is that there's a reason that it's there, right? And there are very good reasons that it's there, in my opinion. okay?
Completely agree.
So, because you can pack or crack all day long, and then you've unfairly disenfranchised minority groups, and as we know, there have been many eons in our history where that gave rise to the Voting Rights Act. However, it can also be perverted and utilized in a way that claims to be utilized with the Voting Rights Act that's not really required to be. And that's what you're sort of seeing. So there are the partisan gerrymander cases, but there of course are a lot of racial gerrymander cases out there too, and they basically involve things like you have perverted the Voting Rights Act and done something in your maps that it does not require, which is usually packing to create fewer numbers of more heavily minority districts.
Well, again, I appreciate what you're trying to do. I just,
Thank you, Senator.
know, got a few questions.
Absolutely. That's what the hearing's for, right?
That's right.
So it looks like it's, anybody else with questions? Any questions at all? So it looks like we, good time for, some testimony.